Congress to oppose the Criminal Procedure Identification Bill 2020, which was introduced by the Minister of State in this House last week. It was a repealment of the original Identification of Prisoners Act 1920. The introduction of this bill was met with very vigorous protest by the opposition, and in one of the very rare instances that I have seen, that an introductory stage of the bill itself, we had sought a division. The original Act of 1920 was passed by our British colonizers, and they did this in 1920 to control nationalist forces and increase surveillance. And they had authorized authorities to take photographs, to collect footprints, and to collect palm prints, fingerprints of convicted people, and also in certain cases non-convicted, and store them. Now, how tragic is it, how ironic that a century later, 100 years later, that we have an elected Indian government. This is not a British era colonizer. It is an elected Indian government who claims to be more nationalistic than any of its predecessors. And today you are bringing in a law that is more intrusive, that collects more data than the original law, and has fewer checks and balances, fewer safeguards than even the British era law did. It is very ironic. The stated objective of the Criminal Procedure Bill of 2022, which was introduced, as set out in its statements of objects and reasons, is to update the law by taking into account new techniques of measurement and identification that have evolved over the last century. And the bill seeks to authorize police and prison officers to take measurements of those who have been arrested, detained, convicted of any person directed by a judicial or executive magistrate. The key words here are any person. The bill has redefined the term measurement to allow police to take retina scans, iris scans, fingerprints, palm prints, footprints, physical and biological samples, and even behavioral attributes, which are what? Which is your signature, which is handwriting. So anything that is referred to under Section 53 or 53 of the Code of Criminal Procedure 1973 falls within its ambit. The original Act, remember, was only photographs and palm prints and fingerprints. This has increased the ambit. So what is it that is so dangerous about this bill? I'm going to try and explain it in layman's terms so everyone who's watching this can understand how this affects us. Because I remember opposing the UAPA bill, in those days a bill, standing here, and the Honourable Speaker told me that, why are you getting so excited about this? Ye to aatanwadiyon ka liye hai. And I remember answering, saying that, sir, if this bill comes in, tomorrow there is a risk of all of us becoming aatanwadis. And the UAPA has been misused, and today we have a fear that this bill itself may be misused, which is why we are standing up today. The most dangerous and insidious aspect of this proposed law is the grouping of those booked for preventive detention. So Indian citizens, like all of us sitting here in the opposition, we can be arrested or detained even before the commission of any act of criminality. You may think we will do something, you may think we will say something, and we could be put under preventive detention. So before doing anything, you can take me and I will be grouped with those arrested for serious offences and convicts. So if this bill becomes a law, I mean, we are entering a full-fledged police state. Any opposition will be brutalized into silence. Now, that is something we must safeguard against. The Home Ministry says, trust us. Yes, we would like to trust you, Mr. Home Minister, but even in UAPA, look at its misuse. You brought in this bill, look at its misuse. I was looking at Mr. Kishan Reddy, who was our Minister of State for Home, putting out the numbers. And if you look at the increase in the number of UAPA cases, from 16 to 19, 5,000 cases were registered and 7,000 people were arrested in the period 16 to 19, but only 2.2% of cases were resulting in a conviction. Preventive detention, 177 politicians arrested in Kashmir after revocation of Article 370, 71 from National Conference, 35 from PDP. When the CAA protests happened, 1,100 people were under arrest, 5,500 kept in preventive detention. There was a 28% increase in the number of sedition cases filed each year. Each year, 28% increase between 14 and 20. So if you look at the arrest of journalists, detentions of journalists in India, I was reading a report by the Free Speech Collective, and it said in the last 10 years, 154 journalists in India were detained, arrested. 67 of these were in 2020 alone. I'm going to now read a quote from the Supreme Court judgment, the State of Andhra Pradesh versus Chala Ramakrishna Reddy, year 2000. The right to life is one of the basic human rights. It is guaranteed to every person by Article 21 of the Constitution, and not even the state has the authority to violate that right. A prisoner, be he a convict or under trial or a détenu does not cease to being a human being. On being convicted of crime and deprived of their liberty with the procedure established by law, prisoners still retain the residue of constitutional rights. Our democracy, however flawed, seeks to give each Indian equal rights as human beings. Our laws are based on the principle of innocent till proven guilty. I will quote the poet Javed Akhtar, and he says it very nicely. He says, "मुझे दुश्मन से भी खुददारी की उम्मीद है, मुझे दुश्मन से भी खुददारी की उम्मीद है, किसी का भी सर, कदमों में सर अच्छा नहीं लगता, कदमों में सर अच्छा नहीं लगता." This bill places the privacy of individuals at the mercy of the state, allows for the retention of personal data with no framework for data protection whatsoever. I appeal to the government and to the Honourable Home Minister, please send this bill to a standing committee for further deliberations if you don't take it back. Thank you very much.
Thank you.
Procedure Identification Bill 2022. The present bill is introduced by the Government of India to authorize for taking measurement of convict and other persons for the purpose of identification and investigation in criminal matters and to preserve the record and same it needs of our. बहुत जब से हम ये बिल पे चर्चा कर रहे हैं, इट इज़ अ वेरी स्मॉल चेंज. अभी तक जो क्रिमिनलों के साथ होता है या जो जिसके साथ ऐसा हुआ है उसके अगेंस्ट क्रिमिनल को सजा देने के लिए जो भी प्रोसीजर करी जाती है, सब बिखरी चीजों को एक जगह लाकर ये बिल में उतारा गया है. इसमें कोई नई चीज ये देश में करना, और आज हम बोलते हैं कि अब्रॉड के बड़ी बड़ी कंट्रियों के साथ हमने compete करना चाहिए, कंपटीशन करना चाहिए, उनके लेवल में आना चाहिए. तो इस चीज में क्यों लेवल में नहीं उतरना चाहिए? इस चीज के लिए भी उनके मुकाबले हमने खड़ा रहना चाहिए और क्रिमिनल को सजा होनी चाहिए. पहले कहावत हम सुनते थे कि चोर की दाढ़ी में तिनका, यही वाला हाल है यहाँ पर इस हाउस में कि जो डरता है वो ये चीज को अगेंस्ट में बोलता है. मुझे लगता है डर के कारण ये सब चीजें बाहर निकल रही है. बिकॉज इन रिसेंट टाइम्स, Mahua, my friend, she spoke in a very aggressive this thing. She was very against for this bill. पर मुझे लगता है अगर कुछ चीजें लोगों को न्याय देने के लिए ये देश में अगर काम करना चाहिए, कुछ रिस्ट्रिक्शंस आनी चाहिए, कुछ सख्ताई आनी चाहिए, तो हर नियम और कायदे में ये सख्ताई लानी बहुत जरूरी है. तब जाके क्राइम और क्रिमिनल्स हमारे देश में कम होंगे. ये इसका सबसे बड़ा उदाहरण है. जो कुछ करेगा नहीं उसे कुछ डर नहीं. तो मुझे लगता है जो नहीं कर रहा वो ये सब चीजों में फेवर में बात कर रहे हैं, और जहां जहां डर है उनके शब्द ऑटोमेटिक निकल रहे हैं. So many accused personally came to be released on bail during pendency of trial of convict. Convict was released on parole or parole, were not tracked out, and they successfully flew away from the clutches of law by changing their visible appearance. They started to live life of another identificant and evade the penalty imposed upon them, evades the expected penalty which is expected to impose upon them. The present bill is an advanced step to the legislative intent to decrease the workload of court and investigation agencies. The bill is opposed on the count that it is unconstitutional as it affects the right to privacy, but the right to privacy is altogether a different thing than the intent act of government. There is no reason to create hangama on this. Against this bill, because even previously if is accused is convicted by the trial court, then the said accused was under obligation to give fingerprints before sending him to jail, and there was no choice with the accused to refuse the same. So now there is no justification to oppose the bill by saying that it contains force. The proposed bill is nothing but the advanced form of identification with availability of advanced technologies. मुझे लगता है कि टेक्नोलॉजी अगर नई चीजें लाएंगे नहीं तो देश आगे कहां बढ़ेगा. नहीं तो 70 इयर्स से हम जहां पे थमे हैं वहां पे ही हम रुके थे. 370 लाए थे तब भी तकलीफ थी, और अगर एडवांस टेक्नोलॉजी लाते हैं, आइडेंटिफिकेशन करवाते हैं, तब भी तकलीफ है. मुझे लगता है ऑपोजिशन को हर बात में इसके अगेंस्ट तकलीफ है, क्योंकि ये काम अच्छा कर रहे हैं और हमारे होम मिनिस्टर हर चीज में सक्षम है, चाहे वो कश्मीर के मुद्दे को लेके हो या देश की सिक्योरिटी के मुद्दे को लेकर हो या सेना पे हमारे सैनिक लड़ते हैं उनके फेवर में बात की जाए. मेरे महाराष्ट्र में कलीग के ज्यादा आवाज आती है. महाराष्ट्र में जिस तरीके से पुलिस हमारे जितने भी लोग कोई भी जुर्म नहीं करते हैं, ऐसे निर्दोष लोगों पे कार्रवाइयां कर रहे हैं, वो उस पे बोलना हमें बहुत जरूरी है। आप मेरे भाई जैसे हो और महाराष्ट्र को बिलोंग करते हैं। आपने हमारी एक मैडम का नाम लिया, अधिकारियों का नाम लेना इस सभागृह में जिसकी ऑलरेडी कोर्ट में जुडिशरी काम कर रही है, उस पे नाम लेना कुछ उचित नहीं है। आर्टिकल 20 सब आर्टिकल 3 speaks about the immunity to accuse against self-incrimination, and this bill nowhere creates evidence of a person which can be used as evidence as against him, but it related to the identification. The bill consciously brought to shattered progress of identification of accused in the existing procedure. The progress includes arrest which contains photographs. Article 21 of Constitution speaks. I know I can do some mistake. Speaks about expectation which says no person shall be deprived of his life or liberty. Experts, according to the established by the law and proposed bill, is just, fair, responsible and proper, which is perfectly maintained balance and right of privacy and maintenance of record of accused regarding this identification. And I would wholeheartedly support this bill and this government and the department, the way this department is working, and हमारी सरकार जिस तरीके से काम कर रही है, देश में क्राइम खत्म करने के लिए काम कर रही है, ना कि क्राइम बढ़ाने के लिए काम कर रही है। थैंक यू सो मच।